In terms of notice, if you're a person who's doing tier 2 kind of activities, you have notice that the person you're dealing with may be designated as a tier 1 designee. I mean, that designation may not have happened yet, but you're assuming the risk because you know that person is within the crosshairs of the statute and they may become designated. So I don't know that the notice argument carries a lot of weight when you're on notice that you're engaging in activity that puts you at risk of being designated.
And may I add to the chief's statement, it also puts you at risk of being indicted and convicted of a federal criminal offense.
Well, what I would say to those points, Your Honors, is that the designation criteria for the tier 2 traffickers doesn't have any knowing requirement. And so really, when Congress was drafting this, they were trying to ensure that people who might be dealing with parties whom they do not know to be involved in narcotics trafficking are not swept into the coverage of the act by those acts until such time as such persons are identified. And to both your point, Judge Srinivasan and Judge Randolph, those persons who are involved in international narcotics trafficking could be designated as tier 1 designees themselves. Indeed, the definition of narcotics trafficking under the statute at 21 U.S.C. 1907(3) indicates clearly that it covers, those activities cover those who aid, abet, collude, or conspire with others to engage in narcotics trafficking activities. So what we're saying is not that persons who are participating in the activities of international narcotics trafficking can't be sanctioned. What we're saying is that tier 2 designation criteria under which Mr. Lopez has been designated is not the appropriate criteria to use in that case. The appropriate criteria would have been the 1904 before criteria.